Thank you for joining us. Today we have Danielle Ruffatto here to talk about protecting your client from violence and harassment. Danielle is the Director of Emergency Services at Edison Justice, where she manages all aspects of the agency's services related to orders of protection, including their walk-in emergency services clinic. And honestly, there is no one with a better legal mind that I know to talk with us about issues related to survivors of domestic violence and the harassment that they face. So I'm excited for you all to talk with Danielle today. So Danielle.
Hi.
Hello.
Welcome everyone. Hi, thank you, Brent, and welcome everyone, and thank you for joining us. As Brent mentioned, I am the Director of Emergency Services at an agency called Edison Justice. And what I'm going to talk with you about today is a little bit about what my agency does, quite a bit about orders of protection, and then we're going to touch a little bit on other related types of orders, and also on what COVID-19 what kind of impact that has had on domestic violence as a whole, as well as how my agency and others in the field have responded to those needs and those particular situations. Next slide, please. All right. So Edison Justice is an agency that aims to provide holistic legal advocacy and systemic reform, and we focus on gender-based violence and the child welfare system. So what does that mean? We have two main divisions. The first one being emergency services in our Order of Protection Division. And emergency services focuses on what someone needs soon after they leave an abusive relationship or while they are actively dealing with an abusive relationship. So we have a walk-in clinic where we provide services, typically what we call brief services, paperwork preparation and advice for individuals seeking orders of protection. And we also do representation. So we usually examine cases at a weekly meeting and take quite a few of the ones that we helped in our walk-in clinic. Then we also have our extended services division, and that is split up into 4 areas of law. 3 of them are limited to survivors of gender-based violence, and 1 of them is not. So to talk about those first, we have a family law division which deals with standard family law, divorce, parentage actions, and represents survivors of domestic violence. We have our Independence Project, which is an immigration project for survivors of domestic violence. Economic justice, which I think is in some ways the hardest to describe quickly, because it is a particular attorney who works on a number of specialty areas and special forms of relief or protection for survivors of domestic violence related to economic issues. And then finally, we have our Family Defense Division, and this is the newest one. And we advocate for and represent families in the child welfare system. And that is not limited to survivors of gender-based violence. However, often there is a great overlap between the clients who need services, for example, in orders of protection, and need help navigating the child welfare system. When we say holistic legal advocacy, what we mean is, I would say, 2 things. Number 1, we have set up our processes so that it is fairly easy to refer cases between our two different divisions, but also between all of our substantive areas. So for example, we have different intakes for the divisions, but if we are already helping you with one issue, we just give you 1 or 2 sheets of paper with the additional information that we need so that we can make a decision. We all use the same case management systems. We have a location for our documents. We share a lot of case notes with each other, and really you try to use that to keep each other in the loop. But also that each office has a client support coordinator who works sort of like a social worker or caseworker on helping to ensure that our clients have their other met non-legal needs. So support, advocacy, help connecting with services, help applying for benefits, things like that. Next slide, please. Okay, so what we're talking about today are protective orders. And generally speaking, a protective order is a type of court order that protects one person from abuse or contact by another person. And in Illinois, we have 3 types of what I refer to as individual protective orders, meant to keep one person safe from another person. We have orders of protection, and those are the oldest and most commonly used one, and that's the one we're going to talk about most today, which involves situations of domestic violence. We have the stalking no contact order, which is set up for cases that involve stalking or harassment if they do not involve domestic violence. And then finally, there is the civil no contact order, which is for issues of sexual abuse or sexual assault, unwelcome sexual contact of any kind, really, that, and there's no requirement related to relationship. So there's 3 different types of orders. There's some overlap between them. Some are, in some cases, you might be able to get 2 types of orders. In some cases, absolutely not, one or the other. There's also 2 types of restraining orders, and I feel it's necessary to mention these, but they're a little bit different. So one of them is for employers who want to get protection for their workplaces and employees. If there has been either an incident or credible threat of violence at the workplace. And then there's a firearms restraining order, which allows certain family members of an individual or law enforcement to go in and ask for someone's firearms to be seized if there's a significant danger of injury to themselves or others. So there's 2 things about those. One of them is that they both involve something that's a little bit different than one person getting protection from one other person. We can get an employer can come in and get protection for all of their locations and employees, for example, and a law enforcement officer can come in and get a firearms restraining order. The other thing is, in both of those situations, that applies to a variety of, both of those orders can apply to a variety of different situations. So we can be talking about domestic violence. We can be talking about, though, like an incident that could turn into a mass shooting, a disgruntled employee, or someone who is suicidal and a threat of, there's a danger of injury to themselves. So just to separate those 2 things out, not to forget about the workplace and firearms restraining orders, but to explain why they're a little bit different. Next slide, please. Okay, so again, we're going to spend most of our time focusing on orders of protection. Orders of protection have been around since 1986. That is by far the oldest of all of the statutes I just mentioned. It involves domestic violence, which is my focus, my agency's focus, but procedures for stalking no contact and civil no contact orders are very similar. There's a lot of overlap in how these types of orders proceed. So I'll try to point that out when those issues come up. Next slide, please. Okay, So what's an order of protection? I think it is good to start with this slide, which is a miscellaneous kind of list of things that are special about an order of protection. So I think the most important one is sort of hidden, which is the middle one. So an order of protection is a court order, right? Keeping one person safe from abuse or contact by another person. But what really makes it powerful is that if you violate a protective order, you have committed a crime, even if what you've done would not otherwise be criminal activity. So for example, if an order says no contact and you text the person to say, hi, how are you doing today? That technically is violating that protective order. It normally wouldn't be, rise to the level of harassment or some other crime. There's also, though, some things that are done with orders of protection to that are listed here to both make them accessible to individuals, even if they don't have an attorney, to make them affordable, and to also provide protection. For example, if someone is unable to seek an order because of age, health, or disability, someone else can seek one on their behalf, and they can protect their whole household. The last one is just to keep in mind that we're trying to pay special attention to characteristics of domestic violence with these orders. And so some things like a confidential address is very important in some circumstances, because an abuser might not know where a victim is living anymore. And we certainly don't want to give them more information. Well, that might not be as much of a concern in various other situations, but it is here. So these are all things that are particular parts of the statute that makes orders of protection different and unique. All right. So we have the Illinois Domestic Violence Act of 1986, the IDVA, which is the law that allows for orders of protection. And it says a few very important things. In particular, the court shall issue an order of protection if the court finds these two things. Shall issue is mandatory language. It means that if court makes relevant findings that someone has been abused by a family or household member, they have to issue an order. And there is case law backing that assertion up. The other thing is that there's two prongs that are important when we're determining whether or not somebody is eligible for an order of protection. We need to know, number one, have they been abused? And number two, if it is in the hands of a family and a household member. So the next thing we're going to do is quickly go through what does abuse mean and who qualifies as a family or household member. Okay, so these are the forms of abuse that under the Domestic Violence Act would constitute domestic violence, would allow someone to seek an order of protection. I'm not going to go through all of them in the interest of time, but I'd like to talk about the first two because those are the two that we see most often. So first of all, physical abuse sounds pretty obvious, but there's a few important points here. Physical abuse includes any, unwanted, unwelcome physical contact. So we're talking about not only the most serious forms of abuse, like choking, punching, things like that, kicking. We're talking about pushing someone, holding their arms so they can't move, poking them, shaking them, things like that. And it also explicitly includes sexual abuse or assault. So there's no question that that is physical abuse under the act. The other area is harassment. And harassment is defined very broadly under the Domestic Violence Act. And it is unreasonable conduct under the circumstances, unreasonable behavior that would be expected to and does actually cause some sort of emotional harm to the petitioner. And so these are examples of things that constitute harassment. Most often we're dealing with one of the top two. The third one also comes up in those cases, but we're often dealing with a case where the content of the contact is threatening to physically harm the petitioner, family members, children, animals, property, where there are direct threats being made. The other form of harassment is constant or frequent, I guess I should say, telephone calls, text messages, emails, social media contact. Stalking comes into play, just driving past, putting someone under surveillance. The act, again, is very broad, so we're not limited to these specific examples. For example, snatching a child without telling the other person where they're at or allowing them to see their child is an example that's given of a type of harassment that's presumed to cause emotional distress. But these are the things we tend to see most often. I noticed there's a question in the chat box, and please feel free to chat away if you have questions. Somebody asked about what about threatening self-harm or abuse? Like, if you leave me, I'll hurt myself, I'll kill myself. Absolutely. That is something that comes up in our cases and that we feel is a pretty clear type of harassment. It can often be a form of manipulation. Like, if you leave me, I'm going to harm myself, so then you have to stay with me. So it pretty clearly fits into that definition. We have had issues from time to time with the judges not recognizing that, or not seeing kind of that is all that has happened. But generally speaking, we're pretty consistently able to get orders of protection if that, and typically that is among one of the forms of abuse that is occurring. One thing I should say is we're not going through DV 101 as part of this presentation. However, domestic violence typically is seen as a pattern of behavior with the aim of exerting power and control over the person that you're abusing. And so it can happen, but rarely does someone come in and there's one incident of physical abuse and there's no history of harassment. Typically, we have a history of various forms of abuse, and often it escalates from emotional abuse, harassment, threats, to more serious forms of physical and sexual abuse. All right, moving on. What is a family or household member? And this is a pretty broad category in Illinois. This category includes a lot of people. So anyone who is or ever dated, anyone who is or previously was married, anyone who has a relationship through blood, current or prior blood or marriage. So that includes in-laws, stepchildren, and beyond. People who have or allegedly have a child in common, even if they didn't have a dating relationship. People who have or in the past have shared a common dwelling. Common dwelling meaning a residence, a unit, a single family home. So a roommate would count, but not a neighbor in a 3-flat. There's some special kind of allowances for people with disabilities and their assistants and caretakers. There is the recognition that once two people have a child in common, their families are pretty tied together. So a relationship through a child exists. So for example, a grandmother of a child against the other parent. And then there were some changes that are made. They were made in kind of a weird way, to be honest. So there were some changes in language to make sure that it was clear that it's clear that family members, so I'm trying to think of how to best phrase this. Individuals who are in foster care or potentially going to be adopted or have recently been adopted, that their blood relatives and other family members are considered family, and so that they can get orders. I don't think that was really unclear in the past, and a lot of times we're getting orders on behalf of someone. So like an adoptive parent on behalf, or a foster parent on behalf of their foster child against the biological parent, and then the child and the parent have a relationship, but the law was changed to specifically include them. There was another question, which I think is important to address. How much is frequent? Like contact, text, does it take into account surrounding circumstances? Yes. So in terms of what constitutes harassment, it's reasonableness. So that is to some degree up to the judge's discretion. But so you do have to, yes, absolutely consider what's going on. So for example, if somebody broke up with their boyfriend or girlfriend and called them 5 times a day for the next 3 days, like say long-time relationship, that might not be considered unreasonable behavior. But what if that happens like a year and a half afterwards? That might be considered unreasonable behavior. If somebody is calling a million times or texting a lot because their kid is with you and they can't get in touch with you, I don't know that anything they do would be considered unreasonable personally to try to get that kid back. But if that's not the situation, someone just says, no, you know, we've been dating for 2 months, I'm not comfortable with this, I'm done, and then you blow up their phone and their email for like days and days and days. What I would say is we're usually focused on either a lot of contact or the content of the contact. So persistent contact that goes on for days, that is like multiple phone calls, where someone tries to cut off contact and the other person will not stop, moves to different method, like uses different types of contact to try to get in touch with them. That is a pretty clear, like the person blocks them on their email, so then they start contacting them on social media and they create a fake Facebook account and try to friend them. And I mean, that is pretty clearly harassment. If there's 2 text messages saying, I'm going to come over and I'm going to shoot you, that's enough to get an order of protection too. So we're typically looking for is either threatening content or you know, ongoing persistent contact, or sometimes it's both. There will be times though where there is a few random text messages that aren't threatening, or a few phone calls, or maybe for the last week someone's been calling you twice a day, but that's all they've been doing, and if you don't answer they just hang up. That might not be enough. So sorry, I'm gonna step back to what we were talking about before. I hope that clarifies it a little bit. I mean, I guess the end answer is there isn't case law that says you must call the person 15 times to be considered harassing. It is very dependent on the circumstances, and it's partially dependent on the discretion of the particular judge you're in front of. All right, so moving on. Okay. So in order of protection, you must have been abused. It must be at the hands of a family household member. We've talked a little bit about those 2 things. And then there are a variety of remedies that are available. So an order of protection is not a one-size-fits-all order. It's not automatically you have to stay 200 feet away from me and that's the order. Survivors can kind of pick and choose what they feel makes them more safe and ask for those things. And some things on here are not going to apply in every circumstance, or it might be a this or this. So for example, you can ask for exclusive possession of a residence, meaning the other person cannot come to or stay there at any point, or you can ask that they be allowed to come in the home, but not while they're under the influence of alcohol or drugs, and therefore a threat to your safety. So you can do one of those 2 things. You can't do both because they would contradict each other. You can't say you can come in at any time. You can't say you can't come in at any time, but then also you can come in except while you're under the influence. Like those 2 things cannot coexist in the same order. There are a variety of remedies related to children in common. It allows the court to order, restrict, or deny, or reserve parenting time. And I bring that one up specifically because again, this isn't a one-size-fits-all order. Every situation is different. So in a lot of cases, when we're petitioning for an order of protection, at the early stage, we're asking for visits to be reserved, for there to be no visits. However, we do occasionally have situations where our client, the petitioner, wants there to be visits and feels that they and their children are safer if visitation continues in a certain way than they would be if they completely just cut off all visits. Sometimes judges don't want to go for that, and that's understandable, but it's understanding that that each situation is different, and we want to be able to conform these orders to those circumstances. So there's 4 categories, I guess I would say. And the first one that I pulled an example from was limiting abuse and other contact. So that's one way that we can help survivors. The second one is addressing issues related to children in common, and I gave an example of that, but there's a lot of other things that can be put in an order related to kids in common, so that that's not a barrier to someone leaving an abusive relationship. Like, how will, you know, my ex see the kids? Next slide, please. All right. There's also some remedies, protection for property or reimbursement for expenses due to damage. Keeping in mind that property damage can be a mechanism that abusers use. And also this other remedies to increase safety. So there are some miscellaneous remedies that the court is allowed to grant that are with the aim of preventing further abuse. So one of them is ordering the respondent to counseling. The other one is prohibiting firearm possession. And while the law has very particular requirements for entering this and awarding this remedy, in Illinois, there's a separate law, the FOID statute, that lets you get a firearms owner identify, like an ID, a firearms ownership or owner's ID, card, and your FOID card is automatically revoked if you have an order of protection issued against you for the duration of that order. That means that when that card's revoked, you lose your ability to legally own a firearm or ammunition, or to have those in your possession. So in a way, getting an order of protection automatically can address some issues of firearm possession, but it's not as strong of an order because it doesn't order someone immediately to turn over their weapons. The third one is sounds a little odd, but it is very important, and it's a newer remedy. So if a petitioner and respondent are on the same cell phone plan, and the respondent is the one who is responsible for the billing, it can order the cell phone company to basically sever that account and allow the petitioner to keep their cell phone number, so that the abuser can't use that as a form of control. They can't, keep their cell phone number or shut off their phone when they want to. The petitioner has to take over the billing and everything. They can keep their number. And then there's just sort of a miscellaneous other injunctive relief portion of the statute that allows judges broad power to do things and put orders into place that need to, in order to keep the petitioner safe. So a good example of that is we get cases involving the threat of or use of threat to use or use of explicit pictures or videos that might have been obtained with the petitioner's permission or might not have. So we'll ask that those be turned over and not distributed or disseminated in any way. Next slide, please. All right, so I know that I'm going through this quickly because there's a lot to cover, but just so we can take a step back and realize kind of where we've come so far, what we've been through so far is we've addressed why, what an order of protection is, who qualifies for it, and what it can do, meaning what it can actually say, what remedies are available. Now we're going to talk a little bit about the procedure for seeking one. And so if we're talking about a civil order or an order of protection, there's a way to get one in a criminal case. It is called a protective order, but it is the same thing. In connection with some civil cases, certain types, such as family law cases, you can get an order in that same case. Or as a civil independent case, which is what we deal with typically at 555 West Harrison. Someone comes in and they want an order of protection, and we need to help them file the paperwork for that. There are technically 3 types of orders. One of them is an emergency order, which can last for 14 to 21 days and can be granted without any notice given to the respondent. And then there's a plenary order, which that happens after service has occurred. And that one can last for up to 2 years. There's also this additional category, an interim order of protection. In Cook County, these are very, very rarely used. So technically it's there, but generally we're talking about emergencies and plenaries and that sort of pathway going from an emergency to a plenary. Next slide, please. Okay, so to talk about that process in a little more detail, the 2 parties in an order of protection case are the petitioner and the respondent. You can file and go up to court the same day and have the judge make a decision on 2 things. So if you look at the bottom, it's not a very fancy graphic, but it hopefully gets the point across, that someone can come in and petition, and so file the petition and go up to court that same day to ask for an emergency order. The judge makes a few decisions there, and then you move on to the next step, which is service. And if service is achieved and you still want that plenary order, you can move on to the plenary order. I mentioned that the judge makes 2 decisions. So the first thing is, if someone goes in front of a judge, the judge can grant the emergency order, which takes effect immediately, and then that's served on the respondent. The judge can also say, I don't think that this case is an emergency. I don't think there's enough here for me to give this emergency order. However, I will continue this case, send it out for service, we'll keep the petition going. So the case continues even without that emergency order. We'll do service and we'll do the plenary order. The third option is that occasionally a judge will hear a case and say, there's not really abuse that qualifies under the act, or you filed the wrong type of order, you're in the wrong place. But this is just not a case that falls under the Domestic Violence Act. So the judge does have the ability to say no to both. No, I'm not going to grant the emergency order, and no, I'm not going to let this case continue. So out of these 2 choices, does this seem like an appropriate case for an order of protection, and do you get an emergency order? We really get 3 different options: yes to both, 1 to 1 and not the other, and no to both as possible outcomes when someone first petitions. Next slide, please. Okay, so these are the 3 options for what the judge might do. Again, grant the emergency order and continue for hearing on a plenary order, deny the emergency order, but continue the matter for hearing just the same, and just deny the whole thing. Don't grant the emergency and dismiss the case. Next, please. Okay, so I'd like to talk a little bit, now that we've gone through this procedure, of what is required for an emergency order. And there is a distinction between what the law says and what judges do in practice. So if you look at the first part, the law basically focuses on potential harm if the respondent were given notice or prior notice. So if we told the respondent that the petitioner was here trying to get this order, or that they were getting the order, and we sent them, we sent the sheriff out and said, okay, they're trying to get this order against you. Here's a court date in 2 days. That would put them in danger, that there would be danger of further abuse during that period. So we really need this emergency order in place right now. Practically, judges usually look at, and this is a made-up word, the recency of the abuse, how recent the most recent incident or behavior was. So if we're talking about harassment, how long it's been going on, but also just answering the question of why someone's coming in now. So is it something that is continuing? Is it escalating? Has there been a recent threat that seems worse than other context? What's going on? And if there was a delay in seeking an order, and a delay is sort of up to the judge's discretion what that means, but usually if it's been longer than, I would say, a week or so, we kind of proactively explain in our paperwork why the person didn't come in the next day to get an order. One thing I want to say about this is, it can seem some people in the past, when I've done presentations, have questions. Well, like, why would a judge not want to give an emergency order? Why would they want to take the chance? Like, why not just give it? And I think there's two things to consider about that. And one of them is that judges do not like, as a group, ex parte orders without notice. And if you think about how our system is set up and how due process generally happens, you generally have someone who files a case, and then the other person served with the paperwork and has a chance to respond, and then everyone comes in together. And so the judge can hear from both sides, with both people understanding the allegations and having had some time to think about that. This is not that. This is a situation where we're saying, make this emergency decision without the other person even knowing that this person is here. So some judges are understandably, concerned about making the wrong decision. The other thing is that some of the remedies definitely impact the respondent, particularly if you are dealing with a couple that lives together or that has kids in common, where an order of protection might kick someone out of the home. It might say you can't see your kids for at least 3 weeks that you're used to seeing every day. It can sometimes result in the loss of a job. And I don't want to overstate that, but for example, if someone needs to carry a weapon, they can't legally have a weapon. So they may lose their job or be put on leave while this order is in effect. So there are absolutely some real consequences to a judge issuing this order. Next slide, please. Okay. All right. So to talk a little bit about what happens next, a lot of our focus the first day someone comes in is with preparing the paperwork, getting people up to court, and trying to get this emergency order. We're trying to get the first step done so someone is protected. However, that is not the whole case by a long shot. And so what happens after that, we'll take a breath, and then the sheriff's office goes out and serves the respondent with all of the court paperwork, including what led them to seek the order, including the allegations. This is pretty important to make sure that we make sure our clients know. It's easy to get in the habit of saying, oh, the sheriff will notify the respondent or let them know about the case or tell them about the court date. But that doesn't capture necessarily that what they're doing is handing copies of everything that has been filed in the case to the respondent. And so some of our clients have a little bit of concern sometimes about including certain instances that they think might anger the respondent. Knowing that once a respondent has been served, the petitioner can ask for that plenary order for up to 2 years at the next court date. But also that these cases often get continued, and the procedures in different courthouses in different counties are very different, and part of it has to do with volume. There are some counties where you come back and the expectation is you're going to have a hearing that next return court date, and then we have a really high volume courthouse like 555 West Harrison, where that's just absolutely impossible for the court to do that because there's so many cases, and a lot of them settle in other ways. So the court allows time for that first. Next slide. Okay. So I brought up that there are some real concerns about why a judge granting an order and the potential harm that it may cause a respondent. So, and again, the judge is only hearing one side of the story. So, what can a respondent do if someone gets served with an order and they say, oh, this is ridiculous, this is, totally a lie, and I don't want this order against me? So one thing is that there's a special type of motion that a respondent can file to ask for rehearing on the emergency order, and it's an emergency motion. It's with 2 days notice, and that's if somebody has a reason to say the court should not have granted this order. It's really designed for situations where there is a clear kind of error. So there's another way to address this, but for example, if someone said, went in and got an order that gave them exclusive possession of a place that they had no right to be, and so I have the police show up at my door, say, you need to leave, here's this order of protection, and I see that it says that the petitioner has a right to be there. Well, that's my unit, I pay the rent, I'm in the lease. This person has no right to be there. So they clearly lied to the court, and I have my lease and I can bring that in and show the court. That might be a situation where there's a defense, at least as to this remedy, as to why this order of protection should not have been entered, or it should not say that. It's just legally incorrect. The other thing, though, is that they can go to the next court date and request a hearing on the petition, and ask. They can also agree to an order. They can have a hearing, which basically means they're contesting the case. They're saying, I don't agree with what's in here, and so on. They can ask for time if they want to hire a lawyer. That's absolutely fine to do. And so those are things that happen commonly. The other thing, and I didn't put this on here because the subject is how a respondent can challenge an OP, but we sometimes get this question. This is a civil case, so a respondent is not, they receive a summons telling them they need to come to court, or they'll be held in default. There's not going to be a warrant put out for anyone's arrest if they don't show up for an order of protection case, but an order can be issued against them by default with everything the petitioner is asking for. So there is some, obviously some danger to just not showing up to court. Next slide. Okay, so this was sort of covered in terms of what the respondent can do, but just to rephrase that, particularly here in Cook County, there's a variety of things that might happen on return court dates. And we can proceed to hearing on the plenary order sometimes that same day. If the other person's not there, we can ask for a default. Sometimes an order is issued by agreement, and that happens far more frequently than I would have anticipated or imagined when I first started working at Edison Justice so many years ago. The case can be continued, and I mentioned getting a lawyer, but also setting a date when witnesses can appear as a hearing date. A lot of times service takes a few attempts. So before the other person is actually served, the petitioner needs to come into court and ask that their order be extended, and the sheriff make another attempt to go out. So that can be part of it. And also terminating the EOP and dismissing the case. One thing to keep in mind, and this is very important part of our practice as we work with survivors of domestic violence, is number one, that they're the ones who are making the decisions in their own lives, and we need to respect that and kind of credit them as the decision makers. We are their lawyers, but they are primarily, to the degree that it's legally and ethically permissible, they're the ones driving this litigation. But also understanding a few things about domestic violence. And one of them is that it is hard to leave an abusive relationship. There is a cycle of violence. There are a lot of factors that make it difficult to leave. And there's also, as I mentioned, the escalation of abuse over a period of time. And I think that's important to mention in this context, just because it's one of the things that makes it hard to see that when you're in the midst of an abusive relationship, is all the up and down and all the good times and bad times and feeling like things are getting back to being good and then they're bad again. And that can just be very confusing and hard to process. So sometimes people do return to their abusers. The other thing, though, the last thing, is that if we're talking about somebody, we are sometimes talking about clients who might just have other things come up and not be able to return for court, or feel like the emergency has done its job. So maybe it's allowed them to move and the abuser doesn't know where they are and they don't think they're going to hear from them again. That's fine. It's not a failure to get an emergency order and then have someone not proceed with the case if it has helped them achieve their goals. Okay. Plenary orders of protection, it can last for up to 2 years. And there is some of the relief that we talked about that can only be granted after service. And this is a list of the remedies. Again, preventing firearm ownership sort of comes with the caveat that the FOID card is revoked immediately. So technically, you're not supposed to legally have weapons after that point. I noticed a quick question. Okay. Oh, yeah. Sorry. Where courts have generally ruled in terms of social media, would messaging on social media equate to emailing? What about consistently posting public threats to someone's life? Yes. So again, in Illinois, again, going back to the definition of harassment, it's very broad. It doesn't specifically say email. It actually says, unreasonable behavior that would cause someone emotional distress. So absolutely, it doesn't matter the form of contact. It doesn't matter if it's phone calls, emails, Snapchat, showing up on someone's doorstep, sending flowers to their house. It does not matter. What's important, though, is either the volume of the contact or attempts to contact, and the content. And absolutely, there's no threat. There's no you do not have a First Amendment right to threaten someone's life. That is very clear in case law. So you cannot, if you're making a public post that you're going to go kill someone, absolutely that would be considered threatening, but it's also not, that your right does not extend, your First Amendment right does not extend that far. Okay, next slide, please. Okay, and then a plenary order of protection, it lasts for up to 2 years. There's an expiration date, but someone can also go to court to terminate it, modify it, or extend it. So these are just examples of it's not necessarily the end when a plenary order is issued. Next slide. Okay, so I'd like to talk for a few minutes about COVID-19. And this is sort of shifting gears. So I've gone over the basics of what our program typically looks like and what an order of protection case typically looks like. However, there have been some changes due to COVID-19. And so first, to talk about the need for domestic violence services. The need for services has increased. There have been more calls to the Illinois Domestic Violence Helpline in the past few months. They hit their highest single day call level ever. This is a national and international issue. It's not something that just applies in Chicago. I've heard about issues across the country, also this coming up in London and other international cities as well. And it is, I would say both, it's kind of a perfect storm because people are stuck in their homes a lot. They're not able to leave their house, even in the normal way that they would, like to go to work, to go to school. They can't go stay with a family member or friend if there's an incident of abuse and take their kids easily. Not that people haven't done that in extreme circumstances, but it's asking a lot right now. There might not be the same concern about physical abuse and leaving bruises if people are not going to work or not going to school. And it's just a stressful time. There's been loss of employment, there's illness, family members are sick. Like, it's just everything that could kind of possibly cause more, like everything that has happened that would cause domestic violence to be a greater issue. At the same time, there is decreased availability of services because a lot of staff is working from home. Court is limited in terms of what the court will hear and what they can hear, because it's just not possible to open court up and have a few hundred people in a small place. That's just not safe right now. But this also provided a unique opportunity, both to push for the increased use of technology, and lawyers as a group, we're not early adopters. We're like the latest adopters possible. Even technology like Zoom hasn't been used widely before COVID-19, but to also develop some unique partnerships, for example, between rideshare programs like Lyft and Uber and the city, and domestic violence resources, so that if we have a client who needs to leave to go to a shelter or leave a shelter to move, we can get rideshare credit for them to use. And using Airbnbs and hotels when shelters were full or not available because there's so few other options. So it has kind of opened the doors to some opportunities as well. And so next one. So what we personally at Edison Justice did, I mentioned very briefly early on that we have a walk-in clinic. So we're typically having each court day, we usually have a staff and a bunch of volunteers that are at 555 West Harrison working, one-on-one with someone who's come in and needs to file for an order of protection. So what we are doing instead right now is we have a hotline set up. We have distributed the number. We have it's on signs at the courthouse. Other agencies have it. The statewide domestic violence helpline has it. And a staff member answers calls to our hotline during business hours. And then both volunteers and interns and our staff attorneys call clients over the phone, interview them, and pretty much do the same thing we do in the office. We prepare someone's affidavit, their paperwork, we review them, and then we email them into the court. And we get the paperwork filed and facilitate a remote emergency order hearing. So we can, via Zoom, using video Zoom, or if someone doesn't have access, by calling in, so essentially doing a conference call through Zoom, we can completely remotely prepare, submit, and have a hearing on an emergency order of protection that same day. I will just say really quickly, we have both had situations that were caused or exasperated by exacerbated. I was like, that's not the right word. It's been a long day. By COVID, be the reason why someone needs an order of protection. So family members who are living together temporarily, people who have sick family members in the hospital, and there's a question of who is taking care of a child, those sorts of situations that have led people to seek orders of protection, and individuals who have health issues that make them more susceptible to COVID-19, who don't want to go into the courthouse. It is right now still possible to go to most of the courthouses, particularly 555 West Harrison, and file a petition in person, but that is only possible for emergencies. And we are about to start a whole new world July 6th, because we are now going to have status court dates heard via Zoom. So we're transitioning from, this was like a really hard thing to get them to set up the ability to do these orders remotely, just on an emergency basis. And now, as time has gone on, our courthouse is going to be handling almost everything remotely during the next few months. So I know that our time is up, and I want to respect that, but I also do want to ask if anyone has any questions. You can put them in the chat box, or I'm always happy if you do have questions or there's something that I left out. If Brent would be the conduit, I'm happy to answer those later as well.
I am happy to do that if anyone has more questions, but for now, if anyone has any in the chat, we can wait another couple seconds and see. Okay.
Well, if no one asks any other questions, thank you all for joining us today and for listening, and thank you for your questions. It's common for us to get a lot about social media and sort of how do we apply this statute that was written in the 80s to our current means of communication. So thank you.
Thank you, Danielle, and thank you everyone for joining us.